Welcome, and thank you for joining me as we explore the essentials of estate planning and the Gentreo solution. I am attorney Mary Kate D'Souza, and am a founder and chief legal officer of Gentreo. I have over 20 years' experience in the areas of estate planning, elder law, and probate litigation. I have seen firsthand the wreckage when families fail to properly prepare. That's why at Gentreo, we are on a mission to protect 10 million American families. The good news is, by attending this webinar, you are taking a concrete step to learn about estate planning and what you need to do to protect yourself and your loved ones. Please note that at the end of the webinar, there will be an opportunity for me to answer any of your questions. Please type the questions into the text box located on your screen as we go along. I will answer all questions at the end of the formal presentation. Now, let us begin. Estate Planning 101. What is estate planning? Most of us have a vague idea that estate planning has something to do with what happens to our stuff when we die. But in reality, estate planning does a lot more than just saying who gets what when you pass away. An estate plan, broadly speaking, is your plan for yourself and your loved one's future needs. Estate planning is about making your wishes known so that your choices will be legally enforced. It is taking action now so that your choices, your loved ones, and your assets are protected by having the essential estate planning documents. These are a healthcare proxy, power of attorney, will and/or trust, a pet power of attorney, and an emergency card. In addition to these critical documents, you need secure and accessible storage for those documents and your other important information. You also need the ability to easily share the documents and information and to change plans as your life circumstances change. Gentreo provides all of this and more. Let's discuss in more detail the different types of estate planning documents. Most of us are familiar with a will-based estate plan. A will is a legal document that allows you to nominate guardians for your minor children, give gifts to loved ones and charities, and choose the person who will uphold your wishes as expressed in your will. This person is called a personal representative or executor. A will only goes into effect after you die. A good will would also provide for contingent beneficiaries, meaning second and third choices. Remember, estate planning is about preparing for the future. The more you plan and prepare, the more you control the outcome. Some of you may be thinking, I do not own a lot, so I do not need a will. Let's explore what happens if you die without a will, because it's not only about your assets, it's about who you want in control when you die. For example, if you die without a will, the laws of your state determine who gets your assets, but your loved ones will still have to petition the court to be put in charge of your estate, even if it's a very small estate. Ask yourself this: does everyone who loves me get along and think the exact same way? If the answer is yes, congratulations and go play the lottery because you are incredibly lucky. For most of us, the answer is no. People come from families and situations in which there are fractured and contentious relationships. For example, you are living with your boyfriend, but your parents do not like him, and you die suddenly in an accident. Your parents will want to be in charge of your estate, but so also will your boyfriend. Absent a will in which you nominate someone, a judge decides, without any input from you, who is in charge of your estate. Your parents would have priority because they are blood relatives, and they may make decisions without any consideration for your boyfriend and what he would want or what you would want. More significantly, for those of us who are parents of minor children, in a will, you can nominate in order of choice those that you would want to be guardian of your children, should the unexpected happen. Again, if you do not have a will nominating your choices, a judge will decide. Do you really not want your choices to be considered? Most of us do, and that is why we have a will. Having a will allows your loved ones to honor and respect your final wishes, and it minimizes conflict. In my experience as a probate attorney, most surviving loved ones are burdened when someone dies without a will because it causes conflict at an already grief-stricken time. Another consideration when drafting your will-based estate plan is your pets. Have you planned for and protected them? We love our pets and we treat them like family members, but the law recognizes them as assets. What that means is that you cannot leave a gift to your beloved pet in your will. You can, however, give your pet to a loved one in your will so that your pet is taken care of. You can also provide for your pet by creating a trust for pet care, which is one of the products Gentreo will soon be offering. Finally, to protect your pet when you are alive, you can create a pet power of attorney and complete the pet care tile in your Gentreo digital family vault so that your pet care agent could have immediate access to all your pet's daily care and medical needs. Now, let's look at a revocable living trust-based estate plan. This is another way to protect and distribute your assets, but it applies both during your lifetime and after you die. The creation of your revocable living trust is the first and sometimes the easiest step of a trust-based estate plan. A revocable living trust, like all trusts, has to be funded. The trust controls only what the trust owns. So you need to make sure that the trust owns whatever assets you want it to control, such as real estate or bank accounts or IRAs. How you transfer assets into the trust depends upon the nature of the asset. For real estate, you need to execute a new deed and record it at your registry of deeds. There will be a recording fee. For bank accounts, you need to open a trust account and then transfer whatever assets you want into that account. Your bank can help you with that. Funding the trust is critical because remember, the trust controls only what it owns. Let's look at an example. You own a vacation house and a family home. You transfer the vacation home into the trust, but leave the family home in your name. You want your son John to get the family home and your daughter Mary to get the vacation home. And you don't want your bad acting daughter, Eve, to receive anything. You die with only the trust as your estate plan. The trust says to give the family home to John, the vacation home to Mary, and makes no provision for Eve. Your trustee gives the vacation home to Mary, but the trustee cannot give John the family home because the trust does not own the family home. Since you didn't have a will, the family home and all other assets you own individually are distributed according to the laws of intestacy in your state. All three of your children, John, Mary, and Eve, equally benefit and inherit the family home together. Eve now owns a third of the family home, and you did not want her to inherit anything. Mary gets all the vacation home per the terms of the trust and a third of the family home, and John gets a third of the family home. This was not the intention of your trust-based estate plan. This plan failed because your trust was not properly funded. A way that this trust-based estate plan could have been rescued to fulfill your intention would be if you had also created a pour-over will. A pour-over will is a specific type of will in which the only beneficiary of your will is your revocable living trust. So any assets that you own individually at the time of your death gets poured into the trust. If, in this example, you had created a pour-over will, the family home, although owned by you individually during your lifetime, would become part of the trust as per the terms of your pour-over will. At Gentreo, you can create an all-encompassing revocable living trust-based estate plan, which includes a pour-over will. The pour-over will, like any will, also allows you to nominate guardians for your minor children and choose a personal representative to manage your estate. Other important legal documents which are part of an estate plan are power of attorney for healthcare, also known as a healthcare proxy, and a power of attorney for finances. A healthcare proxy allows you to nominate someone else to make personal healthcare decisions for you if you are unable to make them for yourself. A Gentreo healthcare proxy also includes HIPAA authority, so your healthcare agent can receive the necessary medical information to determine what care is right for you. The healthcare proxy also allows you to include important instructions as to your choices for end-of-life planning. Decisions such as, do you want to be resuscitated? Do you want artificial hydration and nutrition? Do you want life-sustaining treatment? You have the option of making these choices known. Usually, if you have strong opinions about these issues, it is important that you express them in a legally enforceable document. Do you want to be the person who burdens your loved ones with these decisions because you failed to take the time to plan? We all have heard these awful stories of life changing in an instant due to some tragedy. Do you really want to be the person who leaves a mess for others to deal with? Do you really want the courts to pick the person to make your personal healthcare decisions? For most of us, the answer is no. We want to decide and to protect those important to us from any unnecessary emotional and financial burdens. Many who join Gentreo do so because someone they loved failed to prepare, and they realize how easy it is to take action to protect all that is important. Another essential estate planning document is a financial power of attorney. Similar to a power of attorney for healthcare, a financial power of attorney allows you to appoint someone you choose to make financial decisions for you if you are unable to make them for yourself. To summarize, a healthcare power of attorney makes personal healthcare decisions, and a financial power of attorney makes financial decisions. Besides these legal documents, other components of an estate plan are life insurance, funeral and legacy planning, and convenient, secure, accessible storage of all your important contact information and documents. Now that we have talked about what is involved in estate planning, let's look at some examples. Consider an older married couple where the husband is in great physical shape and his wife of 50 years, unfortunately, has advanced Parkinson's disease, including Parkinsonian dementia. He makes all her healthcare decisions as her husband. He has a heart attack. Who now can make his healthcare decisions? His wife cannot because of her illness. He never executed a healthcare proxy. His adult children now have to go to court to be appointed his guardian to get the legal authority to make healthcare decisions for him. This has a significant legal cost and involves a lot of time, and the process increases the stress at an already stressful time. Had the dad completed a healthcare proxy, his chosen person could immediately make healthcare decisions for him. Also, with this example, we see how now the wife is vulnerable. Her spouse, who acted as her decision maker, is incapacitated and cannot take care of her or make decisions for her. So now the adult children have to petition court to get guardianship so that they have authority to make her healthcare decisions for her too. So far, we have only discussed healthcare issues, but what about finances? In order to manage dad's money, someone would need to have his power of attorney. Even if all accounts were in both mom's and dad's names, mom is too impaired to do her own banking. Again, the adult children would have to petition court to become conservator for their mom and dad so that they have the authority to manage their assets. Their parents' lack of planning has now cost thousands of dollars in court and legal fees, plus time delays during a medical crisis, and compounded the stress of an already challenging circumstance. Had mom and dad each had healthcare proxies and powers of attorney, naming each other as first choice and adult children as alternates, all of these hassles could have been avoided. The alternate agent could easily begin to make healthcare decisions and financial decisions under these powers of attorney. This is especially true if the documents were stored in a secure but easily accessible location like the Gentreo Digital Family Vault, and they were shared with the adult children. At Gentreo, we like to say, because no one can predict the future, we need to plan for it. Indeed, everyone needs an estate plan. For many elements of estate planning, wealth is not a necessary component. You do not need to live in a mansion with a jet set lifestyle to need an estate plan. In fact, estate planning is right for adult Americans, but many do not avail themselves of the laws that are set up to protect them and their choices. In the example we just discussed, two critical estate planning documents, healthcare proxy and power of attorney, are not tied into the value of your estate. Let's look at another example. A young couple in their late 20s are married a year and now expecting their first child. They don't have much in the way of assets. They are renting an apartment, they own a car, they have a dog, and a modest savings. Mostly, they have student loan debt. Both spouses need a healthcare proxy and a financial power of attorney. They each also should create a will to nominate a guardian for their soon to be born child and to protect their dog by planning to give it to a chosen loved one in case the worst happens. They should also have a pet power of attorney. This document allows them to empower their pet care agent to get veterinary care for their dog and can set a financial limit for that care. This document protects you, your pet care agent, your pets, and your vet. Finally, they need to review their beneficiary statements for any retirement accounts or life insurance policies to make sure that their spouse is the assigned beneficiary. Hopefully, with these examples, you are beginning to understand that an estate plan is preparing and protecting all those you hold dear, and the reasons why every capable adult needs an estate plan. Unfortunately, the pandemic has highlighted the need for even younger adults, those who have just turned 18, to create an estate plan. It is especially important if the adult child is at school out of state or from a divorced family where the parents do not successfully co-parent. An 18-year-old should create both a financial and medical power of attorney, also known as a healthcare proxy, so that someone has immediate authority to act in a medical crisis. Again, sadly, the pandemic has made these unlikely circumstances more likely, so it's all the more important that young adults create at least their medical and financial power of attorney. Fortunately, Gentreo is designed to serve you at each stage and circumstance of your life. So as things change, you can easily change your estate planning documents. Rarely is an estate plan one and done. Why is that? Because the nature of life is change. Who among us has not experienced something unexpected and life-altering? Because our circumstances frequently change, we need to review our estate planning documents to make sure they reflect our current circumstances. I would encourage everyone to at least yearly review all your estate planning documents, including your healthcare proxy, power of attorney, will, and/or trust, plus all your beneficiary statements for your IRAs, life insurance, basically any document that you have to name a beneficiary. I suggest you do this when you are preparing to file your taxes. Consider, has anything changed in your life? Did you get married, divorced, remarried? What about your children? Have any of their situations changed? Have loved ones passed away or were born? Has someone gotten sick? The changing circumstances may warrant a change in your legal documents. As you are preparing your taxes, it gives you an opportunity to inventory your assets and liabilities and make sure that you have taken steps to protect all that is important to you, including reviewing your powers of attorney to make sure you have chosen the person you want to serve as your healthcare agent and financial power of attorney. Throughout this webinar, we have been emphasizing the necessity of creating your estate plan. However, having your documents is not enough. The documents need to be stored in a secure and accessible location, such as the Gentreo Digital Family Vault, so that when an emergency happens, those that you want to be in charge will be empowered to act on your behalf. Let's again consider an example. Many store their important papers in a bank safe deposit box, thinking that this is the smartest thing to do. However, even though it seems counterintuitive, storing your important legal documents in a safe deposit box is one of the worst places to store your papers, unless someone else can easily access it. And even with someone else being able to access it, it's not ideal. For example, you are married. You and your wife jointly own a safe deposit box in Massachusetts. Within the safe deposit box are your healthcare proxies, powers of attorneys, and wills. You were in a car accident while traveling with your wife in Florida and are in a coma, and sadly, your medical team thinks that you are brain dead, which is your wife is by your side and doesn't want to leave you. She knows that your healthcare proxy, which included your advance directives, your instructions about what life-sustaining care you wanted, is in the safe deposit box that only you and her have access to. Now, she needs to create a power of attorney, giving authority to someone in Massachusetts to access the safe deposit box. She has to direct that person to where she has kept the key, if she can even remember. Meanwhile, time is going by. All of this makes a difficult, heartbreaking situation more expensive and stressful. It would have been much more convenient if the documents were stored securely in an easily accessible location like the Gentreo Digital Family Vault, so that with the click of a button, she could access his healthcare proxy and his healthcare choices could be upheld. This example, in a sense, is also a best case scenario because we are saying that there are co-owners to the safe deposit box. Most safe deposits boxes are held in an individual name alone, and if that person is incapacitated, his power of attorney cannot access the safe deposit box because the document empowering his agent to access it is within the safe deposit box. So the agent would have to petition court to become his conservator to access the safe deposit box, which of course defeats the whole purpose of having a power of attorney. Some people choose to store their important legal documents in a safe or lockbox in their homes. Again, does the person you want to make medical and financial decisions for you have easy access to your home safe or lockbox to get the estate planning documents? Many of our families have members who live in multiple states, so this system of storage is not ideal if you live in one state and your healthcare agent lives in another. Now that I have walked you through an overview of the essentials and the necessity of estate planning, let me briefly explain how a Gentreo membership empowers you to protect your choices and your loved ones. Gentreo membership enables you to create state-specific, legally binding estate planning documents. Gentreo offers you a complete plan, not just the documents, but the tools and resources to take care of your family today and tomorrow. It allows you to share those documents with your chosen loved ones who become part of your Gentreo team. It also provides you with the digital family vault, the equivalent of a digital home base, where you and everyone on your Gentreo team knows to go to find important information and documents when the need arises. The Gentreo Digital Family Vault allows you to securely store and instantly access and share documents and information anytime, anywhere. Finally, a Gentreo membership allows you to easily update your estate planning documents and other important information as the circumstances of your life change and evolve. Gentreo helps you through life events so you save time and money, reduce stress, and protect who and what you love. Life offers enough challenges. Do not make it harder by failing to plan. Gentreo makes it easy and affordable to protect, share, relax. This concludes our presentation on the essentials of estate planning and the Gentreo solution. Thank you for attending. We hope you have found it helpful and informative. More importantly, we hope that you will take action and join Gentreo either to create your first estate plan or review your estate plan to make sure your choices and loved ones are protected. We will now move on to the question and answer portion of the webinar. How much is a membership? A Gentreo membership is offered at $9.99 a month, or you can buy an annual membership for $100. Well, thank you again for attending the webinar. At Gentreo, I guess we have another question, sorry. Yes, for ICC employees, it's free. It's been offered free to your company. I'm not sure. The question is free for how long? As long as I'm with the company. I think the offer was for a year, but I'm not sure. I'll make sure that we'll get back to you with the definitive answer. Yes, it's for a year. It's for a year. Sorry, the answer is your Gentreo membership has been purchased for a year. Okay, are there any other questions? Okay, well, thank you again for attending the webinar. At Gentreo, we want to help you to plan and protect for the unexpected so that you can relax knowing your loved ones are covered. We wish you all continued health and safety. Thank you.